Bochum Economic Crime Unit, Bochum ceased investigations in 2008. So the investigations ceased in 2008. This report was drawn, or it is dated the 13th day of April 2011, as appears on page 173 of the bundle. Now, the attorney and client privilege that is sought to be protected is the attorney and client communication that relates to litigation, where a client seeks for assistance and discloses certain information to the attorney, and there's a discussion between the attorney and the client regarding or in anticipation for a lawsuit, or even in preparation, or to get information on whether there is merit in pursuing the matter in the form of litigation. And when I talk about litigation, commissioners, I'm talking about litigation in broader terms, which would also include arbitration. Any dispute that may be resolved at a dispute resolution forum. Now, if one looks at the fact that the investigation ceased in 2008, and this report is dated April 2011, there is doubt that this document was prepared for the purpose of litigation or anticipated litigation. It is now 3 years that this document has been produced. Now, further on, I'm aware, commissioners, that an indication that this document has been in the public domain, or a submission to that effect, has already been made. But for the purpose of this application, or for the purpose of this objection, it is appropriate that I reiterate that this document has been in the public domain for some time, and this document has been quoted or relied on in so many occasions and in so many instances. And this document that we are talking about is actually forms part of the submissions that were made by Mr. Terry Crawford Brown and were submitted to this commission as far back as June 2012. And I do not seek to suggest that those submissions were actually the only basis upon which I submit that this document has been in the public domain for some time. Now, alive to the fact that this commission has made a ruling about the admissibility of this document, I would like to take the opportunity to say that this commission does have the powers to revisit its own rulings. And that submission is made on the basis that this commission is not a court of law. This commission develops its own rules and regulations. And in the event that there is a gap what should be the guiding factor on which way to go and how to go about dealing with that. And my submission is that in the event of any gap, this commission should look at fairness and equity in order to be able to execute its mandate properly. And this commission and the commissioners should make it their duty and their responsibility to make sure that they remove or they do not allow obstacles to stand in their way in their fact-finding mission. Because that is exactly what this commission is all about, a fact-finding mission, so that proper recommendations and informed recommendations may be made and presented. Now, dealing with the issue of the nature of the Commission of Inquiry, I would like to refer the Honorable Commissioners to the Constitutional Court case of the Minister of Police and others versus the Premier of the Western Cape and others, 2014-1, SA1CC. Now, from the citation, you'll see that it's a case of 2014. There is a whole host of cases that were decided on this subject prior to then, but I will only then refer this commission to this Constitutional Court that was decided upon recently. And in particular, commissioners, I would like to refer you to paragraphs 45 and 50 of that case. And may I then proceed to read paragraph 45 into the record? And this is where the court was dealing with issues pertaining to the commission, the nature of the commission, and how the commission should deal with issues relating to, amongst others, evidence. In addition to advising the executive, a commission of inquiry serves a deeper public purpose, particularly at times of widespread disquiet and discontent. In the words of Corriger of the Canadian Supreme Court in Phillips versus Nova Scotia, and it was quoted, "One of the primary functions of public inquiries is fact-finding. They are often convened in the wake of public shock, horror, disillusionment, or skepticism. In order to uncover the truth, in times of public questioning, stress, and concern, they provide the means for Canadians to be apprised of the conditions pertaining to a worrisome community problem and to be a part of the recommendations that are aimed at resolving the problem. Both the status and high public respect for the commissioner and the open and public nature of the hearing help to restore public confidence not only in the institution or situation investigated, but also in the process of government as a whole." Now, permit me, commissioners, to then turn over to paragraph 50. It's just overleaf. And I read that paragraph into the record. "In this context, a commission without coercive powers would indeed be unable to fulfill its mandate. It would be no different from an investigation. The objects envisaged in Section 2063 would never be achieved if police enjoyed immunity from being called upon to testify or produce documents on their policing functions. And I'd like to pause here and say, when reference is made to documents on their policing functions, commissioners, this includes documents that the police normally refer to as privileged documents because they are documents that they use in the course and scope of their execution of their duties. And I'd now like to proceed. May I just proceed? When the target of the investigation is the police and how they fulfill their duties in relation to a particular community, they are obliged to account to a lawfully appointed commission as envisaged by Section 2065. If they were to be shielded from the coercive powers of subpoena, the effectiveness of the commission would falter. The entitlements in Section 2063 would be rendered nugatory, as they would depend on whether members of the police service are willing to cooperate with the commission. Now, the point that I would like to make out of this paragraph, Honorable Commissioners, is that the commissions are at a higher level. And one of the distinguishing factors between ordinary investigation by ordinary investigators, it's the fact that the commissions are closed with the powers to direct whether information should be used in the public hearings or not, bearing in mind the motivation for the establishment of the commission. And generally, the president does not just at every whim refer matters or establish commissions for anything that comes about and seems to be controversial. It is an undisputed fact that the appetite for information relating to this commission has been there since around September 1999, at least to the generally the entire public of South Africa. And I will not then want to talk about even those that came to know about or to get allegations at an earlier stage. And this has been hovering over lingering over South Africa over a stretched period of time. And as you have correctly stated, Chair, when you were trying to look at whether this issue can be put to bed in an amicable way, you have had the opportunity to look at the document. And without giving a ruling, you sort of gave guidelines and just a prima facie view on the desirability or otherwise of the use of this document. And in actual fact, this document is one of the grounds upon which people are generally saying there is some cover-up. So, in the circumstances, commissioners, we, the evidence leaders, who are leading this witness in particular now, would like to request that the commissioners revisit the ruling that was made and find that it is in the public interest, and also it is in the best interest of this commission that this obstacle be removed and this document be admitted into evidence. Unless there is anything else that the commissioners would like me to address them on, I will rest here and maybe reply should it become necessary.
Thank you. Thank you, Chair. I'll try and be brief. Chair, I'd like to respond to the evidence leaders first. The suggestion was there that the Plimpton report commenced in 2008 and it's dated in 2011, and it's not possible that that report was prepared in the context of these proceedings. That, of course, misses the point entirely, because we're not dealing here with litigation privilege. For purposes of this litigation, we're dealing with legal privilege, confidential EU personal data. And that warning sign appears on every page. There was a suggestion by my learned friend that because more than 3 years have passed, one should take account of that. That point wasn't fully developed. But if there's any suggestion that privilege prescribes, well, it's not so under South African law. Not as far as I'm aware. It's not a debt. The submission that the report forms part of the submissions before the Commission is also misplaced, because it is the very report that we are objecting against. It's the report that's annexed to Mr. Crawford Brown's statement that we are objecting against. That he annexed that means nothing. There was some suggestion that this Commission is clothed with more power than possibly a High Court, although that point wasn't fully developed either. My submission in that regard is that this court has extensive powers of investigation. That's ultimately the purpose of this Commission. But the right to claim privilege is a right that is written into the law books. And if I may refer the tribunal to the regulations that were promulgated for purposes of this very Commission. It was promulgated on the 8th of February 2012, and Clause 8, I'm going to read that into the record, provides as follows. No person appearing before the Commission may refuse to answer any question on any ground other than the privilege contemplated in Section 3(4) of the Commissions Act of 1947. Privilege is a substantive right. It is not a right that can be disregarded. It's a right that's afforded to witnesses and to parties involved in these proceedings. That brings me to a response to Mr. Crawford Brown's suggestion that just because you won't find the word privilege in our Constitution, that one can't rely on it. Well, the flaw in that argument is obvious. I don't need to belabor that point. It's a substantive right. The issue of these reports was first raised in a letter that the Commission addressed to Weber Wenzel, and that was in 2003 on the 3rd of April, where the Commission refers to, inter alia, the Debois report, and quite correctly says that these reports are available online, but we, the Commission, are apprehensive about using them. First, because the words privilege and confidential have been inscribed on the cover of both reports. And also, the Commission raised the concern that they were not sure that Ferristal had waived the privilege or had consented to the publication of these reports. It then requested Ferristal to waive the privilege. Weber Wenzel, acting for Ferristal, replied to that in a letter dated 29 March 2013, where they asserted their privilege. They made it clear that Ferristal did not consent to the publication of those records. It sought and it continued to seek the protection of those reports. It then also favoured the Commission with an explanation of the origin of these reports, which is that they were done in relation to investigations and inquiries by a German public prosecution. The fact of the matter is, it isn't Ferristal who caused the publication of these reports. They were, so to speak, leaked onto the internet. And to the best of our research, they were leaked onto a website called greekemi.com, which is it's a website similar to WikiLeaks, from which it's clear that those documents were certainly not put there by Ferristal. Since the response of the 29th of April 2013, there have been a number of communications addressed to the Commission where Ferristal reasserted their claim for privilege. 4 or 5 letters, I'm not entirely sure. There is no new evidence that would suggest that the ruling pertaining to privilege has changed. If I may briefly address the Commission on the issue of waiver. In our law, you can waive privilege in 3 possible ways, either expressly, impliedly, or implicitly. There's all 3 depend on the facts of the matter. You assess the conduct of the owner of the privilege. That's the only party that can ever waive privilege. Nobody else can waive it for them. You assess the conduct. If it's express, it's quite obvious. This is obviously not an express waiver situation. Thereafter, you go and you look at whether or not there's been an implied waiver. And an implied waiver also requires one to look at the conduct at issue, and you ask yourself the question whether, objectively speaking, you can say that there was an intention by the owner of the privilege to waive. Now, if you apply that to the fact that this report was leaked onto the internet and was not put there by Ferristal, the only conclusion that you can draw is that there's no evidence of an intent to waive privilege.
Maybe let me just interrupt you there. I don't think at the moment there's any doubt in my mind that our client did not waive privilege. So I think you can assume that I'm going to accept that your client does not waive privilege. But then that's not my difficulty. I'll tell you where my difficulty is. I think I've seen this document 4, 5, 7, 8 times. One has gone through it several times. And I'll tell you, in fact, what I've done. I have given certain instructions in regard to Tony Georgiadis, and in regard to the second person, Ellington. And I can tell you also what we did. Some of the Tony Ellingford, some of the entities mentioned in this document, we have started looking at them. We've started looking at them. Our forensic auditor has started looking at some of the entities that we are aware of the allegation against them that they have received commissions. We have started looking at some of those things. Now, if that is a position, and then this report, the portion which relates to South Africa, is about 10 pages. The first 4 pages deals with commissions. And the other 6 pages deals with the officers. We have detailed information about officers. Several witnesses have testified. So that is not a portion which bothers me. We have more than sufficient evidence on record about officers. But then about commissions, we don't have any evidence. I've looked at the documents. If I've looked at the documents and I've given instructions to the Commission to do certain things, arising out of what I've seen here, if I say this document is privileged, what does that mean? In practical terms, what does that mean? Because I have taken note of what is written here. I mean, without accepting that, what I've seen in this document is correct. But then the information that was contained in here gave me some leads which we are trying to follow. Now, if we are trying to follow those leads, if we say this document is still privileged, it cannot be used, what benefit is your client going to derive from it? Or whether we allow Mr. Crawford-Brown to read this paragraph into the record or not, we have started following the leads which are contained in this document. So if we say that this document is privileged, what does that mean? What practical effect does that mean? Does it mean that we must not follow the leads that we have started following, we must stop? Because I think that we need to follow up those leads because we need to discover the facts. So I'm not quite sure, if at all we end up saying that this document is privileged, of what benefit is it going to be to the client, particularly the 8-10 pages that refers to South Africa. If you can probably try and assist us in that regard, we'll be grateful.
Thank you, Chair. The courts normally consider the question of privilege in the context of where there's been a breach or a violation of privilege in a particular document. And it's usually in the context of a stay of criminal proceedings or access to a document. But it's typically stay of a proceeding. And there the court will have a look at the privileged document and assess whether or not it influences typically a criminal, an accused person, to see whether or not it affects his right to a fair trial. And there are cases out there that deal with that expressly. The nub of the point is that this document, this Devoir report, the privilege is owned by Ferristal, which means that that document cannot be used against it because the content of it is privileged. And to the extent that there is a prosecution against Ferristal, that would be a consideration. So what it means effectively is that that's information that cannot be used against the person that owns it. That would be my submission.
I understand what you're saying. But then what should I do with the knowledge that I have of the contents of this document? Should I pretend as if I've never seen this document? Should we not try and follow the leads that we found in this document? And that 2-3 people who have been paid a commission. Should we not try and follow up those people and try and find out exactly why did they get that commission? There's a difficulty that I'm talking about. And that is why I'm trying to find out what is going to be the practical implications of us saying that, this document is privileged. Should we stop the inquiries that we're making because, this document is privileged, or should we continue with those inquiries? If we do continue with the inquiries, what will be the purpose of saying that this document is privileged, it cannot be used? I'm not saying that it must be used, but then what I want you to address us on is that can we use the contents thereof, or can we use the information that we have gleaned from this document, which we think it might have an impact on our terms of reference?
Chair, I would have thought...
Just hold on. Okay, you can continue.
Thank you, Chair. I think from a conceptual point of view, if there's information in that report that only exists in that report and nowhere else, that's privileged, and that can't be followed on, it can't be acted on. That's not a lead. Conceptually, if there is evidence that's corroborated elsewhere in other sources, but which is also contained in the privilege report, well, that's not covered by the privilege because the source is elsewhere. And I think from a conceptual point of view, that's the only solution that I can think of. But if there's information in the report, and I don't know if this is the case, but if there's information in the report that you can find nowhere else, that's privileged. And the privilege attaches to that information. I can see no other way around it.
So before my colleague comes in, let me give you a simple example. This report deals about the Mawati plantation project. That information is all over. We've got even much more information than you people have on this report. Now, where does that put your argument about this report being the only source of information?
Judge, that type of information that you can source elsewhere outside of the report is before this commission. But the report is not the source of it. So you can't say everything that's in the report now cannot be acted on, even if you can find it elsewhere. It would be silly. So if I can get back to my two conceptual classes of information, if information can't be found anywhere else but in the report, that's privileged, can't be used. If information can be found elsewhere and it happens to be in the report, well, it's before the commission. And I think that's the simple distinction that I can draw.
Maybe the last one from me. What do you mean when you say it can be used? I know that, in terms of this report, certain commissions have been paid. When you say that cannot be used, do you imply that I cannot follow up those about having paid commission in order to try and confirm whether an offense has been committed or not? This is what you mean when you say that the report cannot be used.
If the information falls into the first category, that it cannot be found anywhere else but in the privileged report, the commission must treat it as if it's never seen it. Conceptually.
Are you saying conceptually, even after reading this report, you must pretend as if I've never read the report?
It's very much like a judicial peek, yes.
Okay, thank you.
I have a slightly different view from counsel. And I'm sorry I didn't remember your name. I'm sorry, Mr. Skalberger. Is that correct? I think it's got to do with the uniqueness of a commission of inquiry, in a sense that it's an investigative body, and it's agreed that it does not necessarily follow the rules applicable to the courts of law. You will find members of the public submitting information to a commission of inquiry on the basis of confidentiality, and they don't want to disclose publicly the information they've given you. They've given you the information purely to assist you in your investigations, to give you leads. I tend to think that you can, contrary to what Mr. Berger says, you can, without admitting a document of this nature, the Commission can utilize the information contained on a confidential basis, use the information as leads. You're not going to admit this document formally as evidence and make it part of the record. But once it's in our hands, I think we can use the information for purposes of our own investigations. Of course, we are not going to write that we got this information from this document. The result of the leads are the ones that may appear in our report if we found something following the information we got in the document. In this regard, I note what the quote that has been referred to by Mr. Terry Crawford Brown where he quotes this passage that reads as follows. A commission is responsible for collecting evidence and obtaining statements from witnesses. It may receive evidence either orally or in writing. It may consider information of any nature, including hearsay evidence and newspaper reports, or even submissions and representations that are nothing more than opinions. It may, and my emphasis is on the expression, it may consider information. It may not be admissible information. The document may not be admissible, but if it's handed to us and we look at the document, we may consider it and use it in the information from the document for purposes of our own investigations. So, for instance, we may decide that this document is not admissible, but the document is still useful to the Commission in so far as we can use it as leads. That is the one view I wish to express on this matter. But then, and I don't know whether you will agree with me, but what was the view I want to propose, that even if the document is ruled to be inadmissible, for purpose of this Commission's investigation, it can still be used. We will, because we're merely considering the information. Any comment on that?
Thank you, Commissioner. Yes. I think one needs to be very careful when one deals with different types of evidence that would otherwise be inadmissible. I accept that the Commission has got different powers to hear hearsay evidence and evidence that has got a much lower probative value than direct evidence. It's a fact-finding exercise. But for purposes of the law of evidence, one would exclude that type of evidence ordinarily in a high court on the basis that it is such weak evidence that it doesn't really further the matter. It might lead to something, but it's either hearsay or it's irrelevant. It doesn't address the issue in question. Privilege is a completely different beast, because privilege can relate to evidence that is very potent and very powerful and persuasive, and that can have an outcome on high court proceedings. Yet the law affords that protection to the owner of privilege to invoke that right. So that's why one should be very careful to compare hearsay evidence with privilege evidence. They're different beasts. And moreover, privilege is a right that's protected in the regulations that governs these proceedings. A witness, I beg your pardon, a witness is entitled to rely on privilege. It is a specified right. I think it's Regulation 8, which I referred the Commission to. In the same vein, the Commission can have regard to hearsay. So one gets with both ends. Have regard to hearsay, but give the person an opportunity to invoke privilege. The tendency by our courts, the Supreme Courts of our country, is to see privilege as a substantive right. It's not simply a procedural right.
I've got something else. And I've noted that this document is very explicit. It's marked very clearly. Let me go to it quickly. 173. It's marked very clearly right at the front. Privileged and confidential. Attorney work product. Attorney client communication. Confidential. It's It's marked very clearly. It's a confidential document. And I do note also that in terms of the regulations of this commission, the only basis on which a witness can refuse to answer questions is privilege. So the regulations that do also recognize the importance or the defense of privilege. And by way of analogy, there is a case that has been on for some time. I haven't read the case, I'll tell you, but the case involving the spy tapes. You've heard about it, those who are South African lawyers. You have heard that representations made on behalf of the president are excluded from the material that was supposed to be supplied to the DA in terms of the court order. I think it is the order of the SCA that those representations made on behalf of the president are privileged and therefore cannot be disclosed to the other party. Don't those representations fall in the same category as the privilege claimed in respect of this document? It's something for some kind of food for thought. It may well be supporting your argument that this privilege cannot be breached.
Commissioner, unfortunately, I fall in the same category. I haven't read that case in full, neither have I considered it, but there are different types of privilege that our law recognizes, from litigation to legal privilege, and there may well be a privilege attached to communications from the President's office. I just don't know enough to responsibly make a submission on that.
Before we make a ruling, Shlomo, do you want to say something? Can I ask you to deal with this question, amongst others? Can we recognize privilege of this and that Ferrell is claiming over this document, and at the same time consider the contents of that document without interfering with their privilege? As I've said, I'm aware of what has happened, of the contents of this document. I have given certain instructions to the staff of the commission. They are following up some of the lists that we've picked up from this document. Can one do both at the same time? Uphold their privilege, but then at the same time consider the contents of this document, particularly those issues which I think are relevant to the commission, and act in accordance with the lists which are contained in this document.
All right, thank you, Chair. It's a bit difficult, but I'll try. Let me start off by just clearing one or two things that my learned friend seems to have characterized my address with. And those are a statement relating to the prescription of privilege, and a statement which says that in my address I said the Commission has more powers than the High Court. Prescription. I have not in any way whatsoever tried to even suggest that privilege does prescribe. So I'm just setting the record straight before I deal with issues. And with regard to the powers of the Commission, I have not said that the Commission has more powers than the High Court. What I have said is that the Commission has certain powers with regard, or different powers with regard to the presentation of evidence. And just to close it neatly, I think it will be appropriate for me to refer to case law. I'm not going to quote a long passage. I would like to quote from the case of Bongoza versus Minister of Correctional Services and others, 2002-6 SA 330 Transkei High Court. In particular, I'd like to draw your attention to paragraph 17. Now, quoting from that paragraph, permit me to read the following into record, where clarity is being given, especially on the powers of the Commission as against the courts and even their distinction. A court of law is bound by rules of evidence and pleadings, but a commission is not. It may inform itself, the commission may inform itself, because it is the fact-finding forum, of the facts in any way it does, by hearsay evidence and from newspaper reports, or even through submissions or representations on submissions without sworn evidence. Now, the commission may even inform itself in the way that it pleases. But when it says in the way that it pleases, it does not then mean that the commission can just act arbitrarily. The focus of the commission will be on executing its mandate properly, adequately, and efficiently. And for a commission that is aware of information, to turn a blind eye to that information and yet to continue to execute its mandate will be problematic because it's contradictory in terms. Now, let me then come to the question that the chair has invited me to address. And maybe before I do that, I should just reiterate that when we talk about privilege relating to litigation, or rather, I think it was Commissioner Musi who spoke about the privilege that is now being claimed in relation to the representations that were made by the President to the NPA also. Now, that privilege is privilege that pertains to litigation, because it is about a case that litigation that has been withdrawn against the President. Now, this which we are dealing with here is the fact-finding forum. So it doesn't involve litigation. It does not seek to make a finding against a particular person. It seeks to gather information in order for it to be able to make recommendations. But those recommendations, of course, they have to be informed recommendations. And the information will come from even sources such as this report that we are talking about. Now, regarding the question as to whether the Commission can then use the information without relying on the document, that, in my view, is a difficult thing to do, because what it means is that you look at the document, you get all that information in the document, and you migrate it to somewhere in order to use it. And the reason is, why should the Commission get into the pains of doing that when the Commission has the power to inform itself as it pleases with an intention of executing its mandate properly? And it is a reality, we can't wish it away, that the Commission is in possession of this document. We can't wish it away, that this document has been in the public domain for some time.
Mr. Makagi, if I may just interrupt. In fact, it's slightly more than just wishing it away. We have already started following the leads as a result of the information that we have a picture from this document. Some of these people who are mentioned in this report, we have already tried to trace them because we want to consult with them. Now the question is, after having started such an exercise, if we do find that this is a privileged document, does it mean that we must stop what we're doing and pretend as if we don't know what has happened?
Chair, with great respect, I would say it would be very irresponsible for the Commission to come across information. But because this information, and that information perhaps is even relevant to the Commission, but because that document is termed privilege, for the Commission then to decide to bury it and pretend it's not there. Bury it somewhere. It would be improper for the Commission to do that. That is why there is a differentiation between the Commission and the Court of Law. And the courts of law depend on investigations that have been done by people that don't have even the powers that you have. Now, if there is that elevation to the position of a commission, and a commission says, oh, it's this, and I will not get deeper even into the question of privilege. When you say I'm protecting this document because it's marked privilege, the question is, what are you protecting? Otherwise, we can all stamp our documents privilege, privilege, secret, 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 and because it is marked secret, I say it's privileged.
I see these are not as straightforward as one might want to think. The reason why the information was used by way of a lead, I think it was on assumption that the document has been given to us to assist us in our investigation and not for purpose of this hearing. I think that was the assumption. But I have this question. Will it be permissible for the Commission to perpetuate an illegality if this document is stolen, for instance? Can we nonetheless insist on using it in spite of the clear intimation that it is in fact it has been disseminated without the consent of the owner, and we know it is privileged. Now, we know, and there's no dispute about that. It's probably stolen. Can we perpetuate that illegality by using it in spite of the fact that it is privileged?
Thank you, Commissioner Musi. What we know and what is common cause is that this document is termed privileged and confidential. And what we know for a fact is that this document is a ferro-style document. But the question as to whether this document is stolen, as to whether this document was put in the public domain by a person that was not authorized to do that, it's something that we cannot say.
Oh, by the ferro-style, the owners of the document. Because the document was prepared by their attorneys for them, and they say so, and there's no dispute about that. It is privileged, there's no dispute about that. It is also confirmed to us that they did not approve of its dissemination. In other words, it has been disseminated without their permission. It's unlawfully disseminated. I think those are two facts that we can accept. One, it is privileged. Two, it has been disseminated without the permission of the owner. Can we perpetuate this illegality?
Commissioner, I beg leave to address the issue of whether the dissemination has been done with consent or not.
Ms. Lomakara, you can accept it. We're going to accept that this document was distributed without the permission of Felstar. I think we can accept it. That is going to be our departure point.
Thank you, Chair. Actually, my submission is that it is in the public interest that this document be used and admitted, bearing in mind that, notwithstanding the fact that it bears the stamp of privilege and it is privileged, this document has been in the public domain for some time. And bearing in mind that this commission does have the power to inform itself of the facts, and the reliance will be on this document, it is my submission that it would not be improper for this commission to admit that document and allow it to be used.
Ms. Lomakara, will I be right to say that it is possible to use the information without accepting the document?
It is possible to use the information without accepting the document.
Because now we haven't accepted the document, but then we have started following the leads. I mean, I did give some instructions some time ago that the leads in this document must be followed. Will that be the correct position? That we can follow the leads without accepting the documents?
Yes, Chair, you can use the information in the document like you have already started using that, unless there's a suggestion that your conduct is unlawful, and I would not subscribe to that.
Mr. Berger's view is that once it is found the document is privileged, you can't touch it. In terms of the law, you can't use it. It's privileged. That's his submission.
Commissioner, I will accept that the information can be used. But as regards the question as to whether the document should be admitted, I have made my submissions and I can't take them any further.
Thank you.
Commissioners, may I make a brief point? Thank you, Commissioners. I'd like to make two very brief points. Advocate Berger relies on the Commissions Act of 1947 for the basis of his arguments on privilege. I would point out that although the Commissions Act is 1947, we are in a new era. We are in the era of a constitutional democracy in which the Bill of Rights is supreme and the Constitution is supreme, not the 1947 apartheid era. And so his reliance on privilege from a 1947 Commissions Act is very shaky. But secondly, Commissioner Musi raises the question of whether we can perpetuate the theft of a document, and I think there must be some dispute on that, but nonetheless, overriding and trumping that argument, I submit, is can the Commission be seen to be perpetuating the practice of fraud? And this is the issue which the Commission is having to deal with. Was the arms deal fraudulent? And it comes back to Lord Denning's maxim, fraud unravels everything, including, I would suggest, privilege. And therefore, this document should be made available to the Commission and as evidence, should be accepted by the Commission as evidence.
You know, Mr. Crawford Brown, we are saying this on the assumption that the document discloses fraud. I'm not sure that is the case.
As you know, my argument throughout this is that the arms deal was illegal, unconstitutional, and fraudulent. And fraud unravels everything.
Mr. Crowell Brown, we hear what you're saying. Even if we don't agree with you, but I've heard what you're saying. I can tell you, I haven't discussed it with my co-commissioner. We'll still do that this afternoon. My prima facie view is that we're not going to allow the document, but we are going to use the contents thereof, because we have already started using the contents thereof. I think this is a position that I'm going to, prima facie, this is a position that I'm going to that we're going to take, that we're not going to allow the document, but then the information that we've already picked up from that document, we're going to use it. As I said, we have already started communicating with trying to communicate with some of the people who are mentioned in this report. I think we're going to continue doing that, because as a commission, I think we've got a duty to try and find facts and investigate them. But it's not a final position. We'll give you something very brief in writing tomorrow morning. That's the first thing. Then the second thing, I had Mr. Crawford Brown threatening about legal action, and Federal Star also saying that there's also a possibility that they might be going to court, if I'm not wrong.
No, there was no indication that we'll go to court, no.
Oh, I'm sorry.
No,
I'm sorry. I'm sorry. I misunderstood you. We'll give that ruling tomorrow morning, and immediately thereafter, then we'll proceed with the evidence of Mr. Crawford Brown. Mr. Crawford Brown, you've heard me what I say. This is what I'm likely to do tomorrow morning. If at all you still want to go to court, please try and approach the High Court by way of urgency, because 9 o'clock tomorrow morning I want to continue with this matter.
So as I think I did say in my communication, it is something that we would not necessarily be doing immediately. It would be something to be considered in the future, depending on the recommendations of the Commission. The Commission, of course, has to make recommendations to the President as to what would be an appropriate course for him to take, including the ramifications of cancellation and the recovery of the money. So we await your recommendations to President Zuma.
Well, so if you do go to court, we'll go to court only at that stage, after we have made our recommendations.
We await that is the purpose of your commission, is to make recommendations to the President.
Also, you're not likely to take us to court now?
Not tomorrow.
No, thank you. There's a suggestion that we adjourn now and start tomorrow morning at 9 o'clock. And in the meantime, I'll try and prepare a one-page document about my ruling. Fortunately, Mr. Crawford Brown said to me he's not likely to take us to court now. Can we adjourn until 9 o'clock tomorrow morning? Thank you. We'll come back in tomorrow morning at 9.
Thank you.